Welcome to All Things Policy, a daily podcast by the Takshashila Institution. We are a bunch of policy nerds based in Bengaluru, and we like bringing fresh perspectives to Indian affairs and Indian perspectives to global affairs. So grab a cup of coffee, sit back, and join us for today's chat.
Hello, everybody, and welcome to a brand new episode of All Things Policy. My name is Kripa Koshi, and I'm a staff program manager here at the Takshashila Institution, where I manage a 48-week postgraduate program in public policy. But today, I'm wearing a different hat as the host for this episode, and hopefully in our time together with my guest, uncover a topic that may not be on the radar for too many, or maybe a topic that folks are very well versed in. But I'm just lucky that we have a chance to explore it a little bit in our time together with my guest. So before we get into our topic, allow me to just formally introduce my episode guest today. Welcome to Atisha Kumar. I'm just going to take a moment to introduce you, Atisha, so bear with me. Atisha Kumar is a lawyer with wide-ranging research experience, actually, in the space of human rights and justice. She's worked extensively, actually, with the government, as well as with non-for-profits. And before joining Daksh, which is where she is currently, Atisha was a research fellow at the Vidhi Center for Legal Policy. She is a graduate of the National University of Advanced Legal Studies in Kochi and holds an LLM in Human Rights Law from the University of Nottingham. Her areas of research include gender rights and access to justice. And I'm really happy that we have you here, Atisha, because access to justice is one of the things that we are possibly going to touch on today. So welcome. Thank you for joining us.
Thank you so much, Kripa. It's wonderful to be here.
Yeah, and wonderful to have you. So I'm just going to jump right into sort of the deep end of our discussion here, which is Today we're hoping to talk about reforms to High Court rules, right? So in our time together, we're going to sort of unpack, what exactly are they? What's the concern that we have possibly with some of the High Court rules? So for those who might be unfamiliar, High Court rules are typically the formal codified laws that have been created by the High Court under statutory powers. So they often require approval by the state government, as well as publication in the official gazette to have the force of law. High courts in India were established, understandably, at different times, but that's sort of meant that they've evolved their own unique set of rules and processes for litigation practices and judicial administration in the courts. So as I understand, over the years, practitioners have found that some of these rules have actually become fairly redundant because of the pace at which technology has been developing. And any new rules that have been sort of added to keep up with the tech needs are done in a fairly ad hoc manner, which means that there are sort of these inconsistencies and gaps that affect the efficient and sort of smooth functioning of the court. So what I understand is really that there's a lot of room for improvement, to say the least. And today, my hope is that Atisha, by joining us, is going to help us unpack some of these, what could be some possible reforms that could be brought about to High Court rules to help streamline existing processes, right? So that's sort of laying out the intention of our chat. Atisha, maybe over to you. My first question, I think, is, I know there's, like we said, there's a lot of scope for possible improvement, and I'm going to put you in the tough spot of having to maybe talk about and narrow down, the three most important propositions that you and your team have sort of made in these draft model High Court rules that you've done some research on. So over to you. What would you sort of say are three things that you'd like to focus on in these model High Court rules?
Thanks, Kripa. That's, like you said, a very tough question because we have tried to redesign the system end to end and bring in a lot of new ideas and keep them as simple as possible. But if I had to choose top three, or I would say my favorite, I would first go with the powers of the registrar. So I don't know how many of our listeners would know, but we have multiple registrars in each High Court, and they are judges of the district court that have been deputed to the High Court for specific administrative purposes. Now, most of their job profile as of now, like I said, they're extremely administrative in nature, but they are judges. So there is a scope of actually increasing their workload a little bit and also the kind of work they do, changing the nature of their work essentially. So one of the things that we have talked about in these redesigned rules is that for things where judges take a lot of time because they're administrative in nature, the High Court judges, I mean, and they also have a lot on their plate. So some quasi-judicial functions that they have, which are not very substantive in nature. And for that, I'll just give you an example.
Sure.
So there is something known as scrutiny. Once the case is filed by a party, there are people in the administrative wing known as the registry who actually check whether everything is in order, all the documents have been submitted, everything is formatted, all of that. Now, multiple mistakes come at that time. There are multiple things
Right.
that they ask the lawyers to correct. And a lot of times the lawyers don't do it within the time period that's prescribed. So there is a constant back and forth between the registry, the lawyers, and the judges also, because they have to keep giving them extra time to actually correct it so that the case can finally come to the court
Right.
and be listed
Yeah.
for even the first time. And
Mhm.
this is generally done by judges. Like the extra time that is provided, more often than not, it's one of the judges who would have such matters coming to them and they would say that, give them more time, let them come back to you.
Mm.
And this is not exactly a very judicial function in the sense
Right.
that it is not a very substantive one. This is something that we feel a registrar can take off a judge's plate because the judges have a lot of substantive matters to really get into. And similarly, there are a lot of interlocutory applications, interim applications. For example, that they want to change something in the pleadings, something as small as, correcting the spellings of the name. Now, that is also something that instead of this coming in front of a judge in the court, in a case that's already going on, can very easily be taken up by a registrar who also does come from a judicial background. It's not that
Right.
they're
And
not
has the
judges, right?
capacity actually to evaluate whether the case
Exactly.
is ready to be
Yeah.
listed.
So this is different from High Court to High Court, and some High Courts did do allow registrars to take it up. We think it should be a little bit more common, and all High Courts should try and strive for that, because judicial time is very, very sacred and extremely scarce. And so it's important to allow as much time to judges as they possibly can get.
Yeah. Yeah. No, I'm convinced.
So
Yeah.
the second one that I think is a problem that a lot of people have spoken to us about, a lot of lawyers as well as judges as well as court staff, is about the fact that the service of notice takes forever. Sometimes it takes years to just notify the opposite party that there is a case against them in the court and then they need to come to the court. And you would imagine that in the High Court, it's not that tough because they're generally appeal cases. So they would already know that something like this might be
Right.
coming up. But that's not the case because most of these notices, even today, go through speed post. And
Okay.
sometimes the addresses are incomplete. Sometimes they're not able to find the addresses, the postal officers. Sometimes there's nobody available to accept them. And sometimes there's also intentional evasion of these
Sure.
notices.
Yeah.
So what happens is that the case cannot move, right? Because as per rules of natural justice, you have to have both parties in the court
Yes.
making their arguments. And you can't really move on in the case till the time the party that's the respondent is actually coming to the court and laying their side down.
Yeah.
So now that the service is something that's not happening, the notice is not getting sent. What is the solution to that? So after looking into this problem, speaking to lawyers, one of the things that we realized that's very easy to do is that there can be multiple modes through which the notice is sent. This is something that is being tried out in multiple high courts, but even then it's more of a, if it doesn't happen through one mode,
That's when you rely on another way to
yes, the
communicate.
second one.
Yeah.
But there's no reason that in the beginning itself, you can try multiple modes.
Sure.
Right? If you have email, for example, as one of the modes, as well as speed post, both can go at the same time.
Right.
Right? Then another problem is that only one address of the respondent is where the service is generally made to. And as a party who has come to the court, I would only get to know whether something is sent or something is not sent during the next hearing. There is no opportunity for me to really find out whether the notice has actually been sent or not before the next hearing of my case.
Oh, I see.
Which is a big problem. So another thing that we have mentioned is that while you can also pick multiple modes, you as the first party, as the appellant, can also give multiple addresses at the beginning itself, and service can be tried to all of these addresses at the same time in the first instance. So it increases your chance of actually getting that
Yeah,
notice. Because
yeah.
if I have an office address and if I have a home address and if I have, let's say, a friend's address or my lawyer's address, because all of these are generally appeal cases, if I try sending a speed post to all of them, at least maybe one of them will get it right.
Yeah. Oh gosh. I mean, I'm just already anticipating the downstream impact of something like that, to be able to dispatch out, 3 identical sort of notices like this might be slightly, I would imagine slightly cumbersome, right? To be able to account for.
Yeah.
Yeah. But I can see why you've landed on that as a possible solution. Yeah. Yeah.
Anyway, it is always the applicant's responsibility to provide all of the details, as
Updated
well as
communication
even
address.
currently you have to provide the post envelopes and postage and all of that. They have to provide it themselves. The court is not really doing any
I
of this, especially in civil cases. Not in criminal cases, it's a completely different system.
Okay.
So in that case, it's not something that is very difficult to do, especially if you're also okay with not sending out speed posts, but you're sending out things like emails. Like that's much easier to do. It's just
Sure.
putting everybody in CC or BCC, right?
Yeah. And I would imagine what you're trying to hopefully trim out is the back and forth, right? When you have something that's returned back to the sender and then to try again, like already there's such an iterative process back and forth. Might as well
Yes.
sort of preempt some of that, and from what I'm understanding, send things out proactively to multiple modes of communication, or multiple
Yes.
addresses as well. Yeah.
Yes. And we are a huge advocate of the fact that everything does not have to be paper based, right? Like,
Right.
we are living in a very digital age, so there is no reason for everything to go only from speed post or courier and all of that, especially where it's possible. Like, obviously there is a huge digital divide and we do have to take that into consideration. So it's more of providing different opportunities to ensure that you have a bigger success.
Right. Yeah, I hear you. And I think there was a third one that your heart instinctively called to when you were thinking of your favorite 3 reforms.
Yeah. So the third one would be that there is a lot of scope for digitizing actually district court records. And the reason, and technically this is not really part of High Court's rules. They can't really mandate this in their High Court rules because that's only applicable to High Courts. But High Courts do also make something known as civil rules of practice or criminal rules of practice for district courts. Now, the reason why we want the digitization of records at the district judiciary level in the beginning itself is because in appeal cases, most of the time the court would call for these records, saying that we want to see what actually happened in the court before us. And when they are asked for that, because they are not digitized, they take forever to actually come to the court. Now, that could be for multiple reasons. One could be that in another case, the same records have already been asked for. That is one of the reasons. So you don't actually know where these records are because there's only one set of physical records.
Right.
Then on top of that, there could be reasons like they're extremely old also, because we know that appeals go on for years and they are just hard to locate by the people working in the court system. And when they are finally able to locate them, they send it again through speed post or courier or somebody. If the High Court is nearby, somebody might even hand deliver them. So that's also not really the best way because they can get lost even in transit at times, right? And most importantly, these records are not in any way indexed. So the indexing that is done essentially is just like one part is called the A file, one part is called the B file, and one part is called the C file. But there is no real index which tells you, okay, where are the evidences, where are the witness testimonies, where is the judgment, where are the orders for interim applications. None of that is really provided. So, and in district courts, there's also a lot of handwritten material. So in criminal cases, especially, FIR a lot of times will be handwritten. Then some of the judges might still be handwriting orders and judgments. And there would be handwritten testimonies from witnesses that would make part of the record. All of this is extremely tough for judges in the High Court to read. And sometimes it's in native languages, right? It might not be in English. And in High Court, the language of record is English. You have to have everything in English. So now all of these things provide a very difficult challenge for the High Court that they can't just read the records in the way that they come from the district courts. They have to have somebody in the registry create better records of the records that already exist,
Oh gosh.
type everything out, translate them, and that is known as a paper book.
Okay.
And it is extremely complicated because it takes forever for them to be able to figure out what is written and actually type it out.
Mm-hmm.
So what we are suggesting is that if you digitize these records, and now with the number of AI tools that are available at your disposal, if the High Court actually impanels as in like suggests that these are the AI tools that we suggest are right, please use these only, they can use even those AI tools to actually have those records digitized. A lot of the handwritten notes themselves can be provided in typed versions through AI.
Mm-hmm.
But whatever is not possible, or wherever translations are required and you can't trust AI, you can actually just have those particular documents translated by an actual code translator.
Right.
And if they're indexed, if everything is available in a digital format, the judge can just open it on their laptop and go to that exact page, which is something that they currently can't do, which is the reason why paper books are made. There is a very long process to this. It takes sometimes about 6 months to just get those records in a format.
Yeah, that's right.
That judges can read.
Wow. Yeah, I mean, I can absolutely see the argument that you're making of how some of these changes might have the ripple effects from making some of these changes could be so significant and help sort of streamline the process in such an efficient manner. I think so. I'm glad that we're sort of on the topic of sort of digitization, and I want to segue a little bit more into. I know that it's fantastic to see the research and work that's been done on potentially sort of new High Court rules, but accompanying it, also I understand that Daksh has worked on draft High Court practice guidelines. And so I, from what I understand, the intention really is to make the High Court rules a slightly broader framework that doesn't actually just need to be amended time and time again, because amending the court rules itself would be a fairly challenging process.
Yeah.
So fantastic. That's what I needed, attested and verified by an expert. And then so just going through, some of the practice guidelines, from what I understand, one of the key features that you've identified there is sort of this end-to-end digital case management. And so there is sort of a case, from what I understand, being made that, a fully digitized court ecosystem should be a salient feature of how the court sort of operates, right?
Yes.
So maybe in your view, I'd be just curious to hear, why do you think, in fact, that this should be an important feature when we're sort of considering the court ecosystem?
So the reason why we wanted to move to a completely digital system, despite understanding that, there are a lot of people in our country who are not digitally literate and will find it extremely tough to move to something like this. Is because firstly, we see this happening through lawyers. We don't really see litigants being involved in the filing and everything else, basically, the actual processes, the procedural aspects in the court. So that is one. The second is that there has been a huge push for e-filing in all of the high courts, as well as district courts and Supreme Court as well. And the reason for that is that now if you e-file something, all the records are going to be digitally available. So they don't get lost. You have everything within one system, easy to navigate. But after e-filing, then what? Is the question that we have constantly been asking. Because if you go to most of the high courts, I won't say all, but many of them, once the case is e-filed, from the scrutiny, which is the process where they check everything, as well as when the case comes to the court, it moves to physical files again. So when you're e-file, you also still have to submit a physical file. So there's duplication of work. And everything other than the initial filing that has been done as an e-file is still on physical paper.
Right.
And so it doesn't actually serve any real purpose. It's just because they're not even updated pleadings. They are pleadings which are wrong. There are a lot of things that get corrected after that.
Wow.
There are multiple applications that come up in a case that are not part of the original pleadings. And then there are pleadings from the other side, from the respondents, the written statement and their record and everything, evidences. All of that is also not really e-filed. It's all physically available only on paper. So the idea behind this particular end-to-end digital case management system is that there should be, for every stakeholder within the system, one dashboard, one place where they can see everything that is filed, and everything should be filed digitally. So judges can see all of the cases that they have on their roster. Only those cases. They can see what has happened previously, what are the next steps that they had asked for once the case is coming for the next hearing. And the only way to do that is if everything is available in one place.
Right.
Same way for each lawyer. I have 100 cases as a lawyer, for example. Now, instead of me having all of these physically in my office and having multiple clerks running around figuring out what's going to happen next, if they're all available on my dashboard, and I will be much more prepared for my next hearing because I can just see what happened previously and what is going to happen next, because it's all part of the same case management dashboard system that we are advocating for. Yeah. So that was the thinking behind this. We also want litigants to have a lot more visibility over their cases. Currently, everything that they know comes from their lawyers, which is a big problem, because while lawyers do, of course, try their best to tell their clients everything, they might not be very transparent about certain things. And they have a lot of things that are happening on their end for multiple cases. So they might not have a lot of bandwidth to deal with the kind of questions that one litigant might have. For all of these purposes, if the litigant also have their own dashboard where they can see what's happening in their cases, and every hearing there is an update, okay, that this was the order passed and there's a summary of sorts of that order. And they can see when the next date of hearing is, they would also feel a lot more comfortable knowing that their cases are moving forward.
Right.
If summons are not being served and it's because an address is not complete, they can see that and then they can provide the correct address. So it just opens up the possibility of having a lot more information literally at the palm of your hands, right? Because you're not dependent on other people in the system to tell you what is going to happen when. Sometimes they also don't have the answers.
Right. Yeah, no, and I appreciate that there is thought also to how to center the experience of those who are sort of litigants trying to engage with the system that can be complex and very convoluted for them to navigate, and how sort of allowing for, like you were saying, this dashboard to be accessible to them makes for eases some of these worries, helps make things that are seemingly complex feel slightly more accessible and sort of simplistic to understand. So I hear sort of what you're saying here, and so I think the one question I did have was, of course, you'd sort of shared as you were answering the question, that a lot of these reforms or these proposed sort of changes that you were putting together for both the practice guidelines and the High Court rules came from this very explicit appetite that you were hearing from lawyers, you were hearing from, different stakeholders sort of in the court system, that this makes sense. So I think my question then is, while the courts themselves may have sort of or different actors sort of in the system may have the appetite for this digitized ecosystem, in your view, do you think they would have the wherewithal sort of needed for a full overhaul, right? And it includes things like what you yourself alluded to, which is digital literacy might sometimes be a challenge, or just completely rethinking the steps in the process, right? So now instead of just running for paperwork, I have to retrain myself to figure, I have to go to the system and now update it with the details for this particular case. So yeah, just your thoughts on that.
So actually, that's a very important question, because we often believe that a lot of things in the codes are the way they are because they don't have the budget to improve things. In our experience, in the kind of research that Daksha has undertaken over multiple years, we've realized that that's not really true. The budgets are not really that much of a problem. It is about how those budgets are being spent. Sometimes we've also had courts returning a part of the budget to the state government, or because they have so much left over and they don't know what to do with it. They don't know how to spend it.
Right.
So, and most importantly, under eCodes 3.0. So this is eCodes 3.0 is what the currently Supreme Court as well as Department of Justice together has rolled out the third version of eCodes, where a lot of changes to the high courts and district courts are envisioned. I think it was in 2023 that 7,000 crores over 4 years have been allocated for just the third phase of eCodes.
Wow.
And in that case management, e-filing, all of these are actual heads where money is being allotted. So
Right. Intentionally directed in those
exactly.
areas. Yeah.
So I think Supreme Court, Department of Justice, High Courts, they all of them do recognize that there is a lot that can be done, as well as the fact that there are budgets available for it. A lot of these changes take time, and you do require specific expertise, especially IT people who will be able to build this system out for you. Something like a dashboard is not something that can happen immediately and without the right people working on it once you have the vision for it.
Sure.
So it is some of the courts are also taking it up. Currently, a lot of these things happen sort of as a top-down movement where NIC is going to build things that it will be rolled out in all the courts, and then they adopt those. And they can have some things which are more specific to them, but most of it is just designed centrally by NIC team. So that is another place where there can be some change. Like if the high courts are willing to move beyond that, they can try and make their own systems. They can try and create systems which maybe work with the NIC systems only, but provide an additional layer to it, which is easier for lawyers to use. Another reason why there's been a lot of pushback on things like e-filing is because the current system is not intuitive at all. It's very difficult to use. You're just scanning one page after the other and uploading them. There is no way of directly putting them on the dashboard. And there are a lot of things which require change. And these are very small changes, right? Like you can just upload them directly. They're more OCR readable. In fact, if you don't have to sign each and every page, you'll be able to do that. But that's another thing in the rules. Most of the high courts require that each page of pleadings have to be signed by both the lawyer as well as the party. So they have no option. They have to scan everything and upload. So these are also the kind of changes that we have talked about, because we recognize that technology is one part of it, but you need an enabler. The rules are the enablers.
Right. I hear you. And I think I hear sort of the optimism also with which you're sort of seeing it, where, the context as well as the money and resources is actually allowing for some of these changes to be made possible, right? So there seem to be some general strides that are being made in this direction that can be sort of done more efficiently or can be done more comprehensively. So I absolutely hear what you're saying. I know you had alluded to, the fact that there have been some examples of different high courts that you've been looking at. And I think while our scope of our conversation has been fairly broad, and even the high court rules that have been drafted from Daksha's side are somewhat broad, I think from what I understand, there are best practices that you've been able to see across the country where certain high courts are already modeling some of what you might propose as sort of like good approaches to how the court ecosystem functions. So maybe would you talk about some of that? Any examples that you've seen of other high courts that have been able to streamline or make their litigation practices more efficient?
Yes. So, like I mentioned, absolutely, there are some courts that are doing an incredible job. And the first court that comes to my mind is the Kerala High Court, which, like I mentioned, have moved away from that NIC system and have developed an in-house case management system, an e-filing portal, and a case management system that is, I wouldn't say exactly similar, but was a huge inspiration for us when we started working on these rules.
Right.
Because we had the opportunity to see that system, to see
how it plays
how
out
it's functioning.
practically. Yeah.
Exactly. And speak to lawyers who are using it. What are the problems that they face with it? What are the things that they love about it? And overall, it was such positive energy that we had from lawyers. Everybody was they were feeling extremely happy about the system. And while it took a while for the clerks to get accustomed to it, they also seem to be a lot happier with their jobs because they don't have to run to the registry all the time. They can sit at home, do their jobs. And overall, it just works great. I think one of the things that we often fear with technology, as well as the kind of technology that simplifies processes, is that there might be loss of jobs. And with Kerala High Court, we can see that that's not true. It's just a different nature of jobs. It's just that your job might require you to do something a bit differently, might require you to focus your attention on something else. But it's not that people are not needed in the system. The court officers, the number of the court officers is the same. In fact, their IT team has increased from I think 5 to 10 people to almost 50 people now. So there is a lot of opportunity to do really good work if, people really want to do it. And that's what Kerala has taught us. And even Delhi High Court is very good at certain things, I feel. For example, one of the problems that we often hear within the High Court system is that cases are often lost within the system. They don't get hearings, they don't get listed, let alone like anything substantive happening in those listings. And they have solved for that by ensuring that every time a new case comes to the court, within the first 2 days, it shall be listed for its first hearing. It has to be listed. It cannot get lost. On top of that, once they hear the case, they always provide for the next date of hearing. They don't just say, okay, put it in next 2 weeks, because 2 weeks can happen at any time, right?
Sure.
So they give a proper date,
They
which
cut through
ensures
that ambiguity by saying, please show up at this. Yeah.
So cases don't get lost within the system. And they are constantly coming up for regular hearings.
Yeah.
And the lawyers know that when is their next hearing. So they're prepared. So the number of adjournments that they take are much fewer.
Right.
Yeah. And the last example I would like to talk about is Madhya Pradesh, because their rules are a lot newer. They are 2008 rules. And you would imagine the 2008 not being very new, but when you look at the other High Court rules that have been made in 50s and 60s, it is brand new.
I hear you.
Yeah, so they have a very new set of rules. They have some really good practices in those rules. But what I love about what they have tried to do is that they have really cute animated videos on their website for lawyers and litigants to just understand things like e-filing and the court processes. And it's such a nice touch for litigants, I feel, especially, who have no idea what's going on.
Sure.
They don't know how the court systems work, but especially if they're a little bit tech friendly, they can just go to the High Court website and the videos are in Hindi. So that also helps people who don't speak English understand exactly what is going to happen. Yeah, so I think those are some really, really good things that high courts are doing. There are, of course, a lot of other high courts who are doing a lot of other things. But yeah, these three, I think,
the ones
are at the top of my head.
No, I think these are fantastic examples. And I think sort of I just really appreciated that, in each there's sort of very diverse ways in which they've tried to tackle problems within the system in their sort of unique way. And like you sort of landed on the MP example where there is a sensitivity to how the litigant is approaching this behemoth of this judicial system, not knowing where do I enter, how can I guarantee some sort of successful outcome for myself or my case in particular. So yeah, I appreciate, I think, all those three. And I think, like you said sort of earlier, that, it bodes well then for possible changes that could happen in other contexts in India, right? If you can see that it's demonstrated successfully in certain areas, and of course you can tweak based on context, but just seeing that it can, how it's played out in some of these settings and, as diverse as going from north to south, I like that you also picked regionally diverse examples. It's sort of great to sort of understand, that some of these reforms might actually be possible at a high court near you, So yeah, with that, I mean, I know that the amount of research that's gone into sort of preparing some of this, both, the High Court rules as well as the practice guidelines, has been fairly extensive, and it's fantastic to even hear how many different stakeholders you had to sort of involve in the process to be able to present a fairly comprehensive view of the system itself, right? And we realize that there are so many folks who are involved in how the ecosystem functions. So really, I think this is an invitation for listeners to be able to do a little bit of digging to sort of see. I think we only very briefly touched on, a few of some of the proposed sort of reforms that Daksh has put forward, but there are, in fact, several different elements that have been sort of tackled in the ecosystem where reform has been proposed. So with that, we'll conclude our time together. But first, let me thank our guest. Thank you so much, Atisha, for joining us today.
Thank you. Thanks a lot, Kripa, for having me. I would just like to add one thing here, that we are looking to get feedback on these rules. We have tried our best to speak to more people and to dig into the systems, but, there is always room for improvement.
Absolutely.
And please, if you have any feedback for us, do reach out to us. Everything is available on the website, and we would love to hear from lawyers especially. We want to make a system that's very good for them.
No, I appreciate that, and I think it's a good thing to keep it somewhat an iterative process where, we don't know what we don't know, and our blind spots still exist on some of this. And so I appreciate that there's room for that conversation and dialogue to still happen. With that, Thank you again so much, Dishya, and to our listeners, continue on to the next episode. But yeah, a pleasure to have you here. Thank you again.
If you liked our show, dive into Takshashila's research on technology, strategy, and economic affairs. Check us out at our Twitter handle @TakshashilaINST or our website takshashila.org.in.